Welcome back. This is the final video in a series of videos I've recorded analyzing the Google Book Search settlement. In this particular video, I compare the settlement agreement in its operative terms and effect to the likely outcome of the fair use litigation which the settlement avoided. Once again, a full set of the slides accompanying this presentation is available at my website, and an article complementing this presentation will be posted very soon on ssrn.com. In the first of these series of videos, I undertook a detailed examination of the Google Book project and how it would have fared if the copyright lawsuits brought by the Authors Guild and the American Association of Publishers had in fact proceeded all the way through to a final judgment on the merits. In the second series of videos, I undertook a detailed analysis of the actual terms and effect of the Google Book settlement. In this final series, I compare the effect of the settlement to what would have happened if there actually had been a fair use ruling. As I explained in the first series of videos, the most likely litigation scenario I can envisage here, if this case had gone to trial, is that the digitization of library books for inclusion in a book search database would be protected by the fair use doctrine, subject to two conditions. First, the final product, i.e. the search results displayed to end users, would not itself infringe copyright. And second, the copyright owners would be provided with a low-cost opt-out mechanism that they could use to withdraw their books from the database. This is just one possible outcome, and certainly things could have gone much worse from Google's point of view. Nonetheless, this counterfactual gives us a useful basis upon which to evaluate the settlement agreement. To make this comparison properly, you need to think about more than just the initial rights and freedoms granted by a fair use ruling. You also need to think about how Google and the copyright owners would have been likely to have negotiated in the shadow of such a ruling. In other words, you need to think about the fair use outcome and the subsequent moves that the players would make in a fair use world. Under this hypothetical ruling, Google would have the right to continue to make non-expressive uses of printed library books by digitizing and analyzing these works. It would have also had the right to continue to report such results in relation to these books, provided that the search results themselves did not amount to a substantial copy of any particular work. Under our hypothetical fair use ruling, Google would not have been allowed to make any substantial previews of the works except for works in the public domain or works for which the publisher or copyright owner had agreed for that kind of preview. Finally, our hypothetical fair use ruling would not by itself provide for a single cent of revenue to any copyright owner. Now we move to the fair use world and how it compares to the settlement. In a fair use world, Google's basic digitization and analysis and reporting would continue, except that some copyright owners would presumably opt out of the database altogether. This is essentially the same as under the class action settlement. In a fair use world, the display of brief snippets of text as part of a menu of search results would continue to be not infringing, provided that it did not cross over the threshold of substantial similarity. The settlement is almost the same in this regard, except that rather than relying on the somewhat imprecise copyright law concept of substantial similarity, the length of snippets allowed is narrowly defined. Under the settlement, and in a fair use world, we would expect some copyright owners to opt out of snippets. It's likely that in a fair use world, some copyright owners would have expressly allowed Google to make more substantial uses of their works, including the display of substantial previews and possibly even the kinds of activities envisaged under the new revenue models discussed in the settlement. However, the number of copyright owners who would have taken such action remains uncertain. In contrast, the settlement sets default positions which allow significant previews of substantial sections of books. Because of the way the default positions are defined in the agreement, Google obtains significantly more access to orphan works under the settlement than it could reasonably have expected in a fair use world. The settlement also contains a number of mechanisms through which authors and the registry acting on behalf of authors can increase the extent of the previews they allow, it also provides a platform for negotiation for the new revenue models. Finally, it's important to note that while we would expect some authors to profit from opting into more extensive uses, or from promising not to opt out of the basic uses in a fair use world, the opportunities for copyright owner remuneration under the settlement appear to be much more significant. What does this analysis imply for an evaluation of the settlement? Comparing the settlement to the most likely outcome of the author and publisher lawsuits gives us an important baseline from which to evaluate the merits of the settlement agreement. However, it's also apparent that this is only the beginning of such an analysis. Questions that need to be answered in relation to the settlement include what, if any, are the anti-competitive effects of the settlement, and how do these compare to the pro-competitive benefits of the settlement? Will the settlement lead to a concentration of market power to the detriment of the general public or specific institutions such as libraries and universities? Does the settlement create a monopoly in any relevant market, particularly in the exploitation of orphan works? How will the settlement affect the incentives of other private, non-profit and government entities to engage in similar digitization projects? Additionally, some might question whether the registry's ability to license orphan works is an appropriate outcome of a class action settlement. Some might also question whether the procedures which allocate rights between authors and publishers and establish a dispute settlement process are actually fair to the authors and publishers involved. All of these questions are for the future and perhaps the subject of future presentations. In conclusion, copyright owners and the general public should know that the extended opt-out deadline for the settlement is September 4, 2009, and that the final fairness hearing for the class action settlement is currently scheduled for October 7, 2009. For more information about the issues raised in this presentation, I recommend, without necessarily endorsing, the websites and articles listed on this slide.